Hello, my name is Manuel Llorca. I work at the Universitat Politècnica de Valencia. And within the NICCoLLa project, I want to raise ethical dilemma from the point of view of technology perspective in sectors more related to the social world, such as health, well-being, or even social activity in groups with difficult to integrate. From this sector, especially in the health sector, the concept of the deontology, ethics applied to the profession, is much more used and is taken into account when making decisions. On the other hand, in the technology sector, the developer, the analyst, when implementing technology, doesn't often ask himself if his performance has to do with ethical issues. In last year, there are been great increase in the development of artificial intelligence. It's important to highlight the specific artificial intelligence, the one that solves a specific problem, not a generalist artificial intelligence. And this has occurred for two fundamental reasons. The capacity of processing of the computer has improved, and the large amount of data that has been stored and managed. And this great advance, has made and huge improvement in the AI. But the question is, when we talk about personal data, when that personal data affects decision making, should there be any limitation? Should there be any law, any ethical proposal that limit the general use of personal data? Well, in Europe, the European Parliament approved a very powerful legislation, General Data Protection Regulation, and try to protect user information in the social network and internet. The fundamental principle in this law can be listed, that there is fairness in the collection of data, that company, institutions are transparent to know at all times what is going to do with our data. Limited the use, that is, for they will collect what you will be made with them, and about all, the time of duration in which they will use our data. It's important to note that the law specifies that the data to be collected is strictly necessary. If, for example, a people have to go to a dry cleaner and they ask their personal data, they strictly should ask the information that they are going to use. For example, if the company needs your email, it's because you send you one. And about all, same thing very important, the data must be completed. It must be accurate, and it must be visible to those who have the right to access to it. In addition, the law also lists the responsibility. Who is the responsible in the case that a problem occurs in the custody of the data? Specifying that the responsibility must be proactive. That is, the company must do everything necessary to safeguard the information, not in case you serve a cyber attack, an attack by a hacker, when personal data may be stolen, you must communicate the problem to the national agency and try to find a solution in the most agile way possible to solve the problem. And what does it protect? It's clear that when we talk about the personal data, everyone has an idea in mind. Our name, our nationality, our international identity number, our postal address, our email. But moreover, the European regulation also has also taken into account all the data that used in social network, in the digital world, and that can identify us in same way. Our location, the IP address, the data that we store in cookies, the login identifier, the publication we make on social network, including the image we have, and so on. And consider the following data of special protection, like genetic data, health data, biometric information, race data, ethnic, political opinion, sexual orientation. This data cannot be requested if it isn't strictly necessary, and the user must expressly accept it in order to be collected. When which right do users have? Which right do all Europeans have when someone to store the data? We highlight the right of access. We have to know what company, what institution, and what data they got from us. We can know the duration of its use and store. We should be strictly used for that it's said. Since the massive use the social network and the compliance about the use of the data, the European Parliament legislative the right to be deleted. Our right to be able to erase the data even if we allow the use our data in the past or once some died. In each, our right to choose what do you think your data, the historical information that they may have about us, and eliminate all traces of it. It must be remembered that the data must be deleted when the specific period of time was expired, when the user consent has changed, or when the legal obligation at the same have changed. The European regulation explains in several articles the use of data analysis algorithm. It indicates that when there is software that can make the automatic treatment of this data, the data must be anonymized. They must eliminate any reference that can expressly identify a person. In addition, people must be aware that their data can be used and accept it. Here is important to note that in the Article 22, it is expressly specified that when the use algorithm take into account decisions that concern group of people, the use of human supervision is mandatory. For example, the immigration, the legal guarantee, and this does not occur in the rest of the country. For example, United Kingdom, since Brexit, the legislation has been changed so that there is the possibility that these decisions are made automatically without human supervision. In different to other regions, Europe is very protectionist, has preferred and has considered that the right to privacy of an individual should be about than the use that can be made of his data. And we as individuals decide what can be done with our data. For example, in the case of China, the ownership of the data collected by public institutions belong to the state. There are cameras in the street with have a facial recognition system with which they can classify people by their positive or negative activities. In the case of United States, with exception, for example, the region of California, which have a law similar to European one, there isn't legislation, and the data belong to the company that collect them. It's worth mentioning especially the 5 big companies, grouped with the acronyms GAFAM: Google, Amazon, Facebook, Apple, and Microsoft. Design and decision-making capacity are enormous. It's important to highlight the following phrases. If you don't pay for the product is you. It means if the company cannot charge for the application that we use for free, they take advantage of your data or your decision-making capacity to sell you a product. Just to point in once more, in Europe, the individual is the owner on their data and decide what should be done with them. It's curious that many people have no problem accepting the condition when installing an application, and instead we refuse the use of official application that can trade our movement, for example, in the case of the pandemic. European law is good because it preserves the right of the individual, but it makes it very difficult for researchers or the technician company to collect data. European countries have a lot of technology depending of other countries, which don't have the limitation and can train the algorithm with much more data. We must consider how this dependency that we have to other countries is affecting Europe. So it's important that we ask ourselves some ethical questions. When two fundamental rights interfere, in this case, privacy, the right of the person, and health, which is a common benefit, which of the two shall prevail? In the case of the problem that has occurred in the pandemic, there have been countries like China or Korea have used technology to control the mobility of people, while in Europe, the use of technology has been residual, and we have used traced the phone a person and trusted the memory. So, from your point of view, with type of management of data according to China, United States, Europe, is better from a social point of view to solve a health problem, particularly in the case of the pandemic. The health sector, the welfare sector, can afford the luxury of being technologically depending of something that is not made in Europe. And since artificial intelligence is the future and is based on data analysis, should there be data for science? For there be battery of public data so the European researchers, especially when it affects people, can work on developing these technologies? So, I would like to end my presentation by asking you to reflexionate about the data issues that the data management can create and how they will affect us in the close future. Thank you.